Hi guys, this is attorney Ade Omojola from Omojola Law. We are located at Toms River, New Jersey. You can search us omojola.law. Just type in OMOJOLA law, and it's going to pull up our website and other information. We're very easy to find. I have been practicing for over 13 years. The areas of focus are litigation, immigration, domestic violence, and DUIs, also known as DWIs in certain states and jurisdictions. Today, I'm going to focus a little more on the domestic violence angle, with a little bit of specificity on the restraining order part of it. A domestic violence case can take on three different dimensions. First dimension is it could be handled as a criminal matter, where the prosecutor prosecutes the alleged assailant for an act for a crime of domestic violence. Under the Domestic Violence Act in New Jersey, the parties must have a domestic relationship, whether it's husband, wife, brother, sister, cousins, boyfriend, girlfriend, etc. So there must be a domestic relationship. And then there is a long list of actions that qualify as domestic violence. Such actions could be an assault, a battery, kidnapping, threats, etc. So where any of these actions exist and where the parties have a domestic relationship, it falls under the Domestic Violence Act, which, as I've mentioned, can be handled. It can have three different dimensions. The first dimension could be prosecution for a crime. The second dimension could be a restraining order situation. And the third dimension could be the alleged victim going after the alleged assailant for damages, which would be a civil case. So out of those three areas, I'm going to focus on the second one, the restraining order, with a little bit of touching a little bit on the criminal angle part of it. With regards to the criminal side of a domestic violence issue, that's up to the prosecutor. Whether or not the alleged victim agrees to cooperate, to give evidence, or to testify, the prosecutor can still weigh the case and decide whether they want to proceed with the case or just drop the case, right? With regards to the FRO situation, which is a restraining order, whenever it starts off as a temporary restraining order, but if a judge deems it necessary, it can become an FRO, which is a final restraining order. How does a restraining order come to be? There are two ways. The alleged victim can either go to the Superior Court Family Division in their county and request for a restraining order. They'll get the forms, they fill it out, it gets handed to the judge. The judge reviews the facts of the case and decides, perhaps talks to the alleged victim and decides whether to grant the restraining order, a temporary restraining order, right there on the spot. Or if there is a domestic violence incident, right, and the police are involved, whether the party goes to the police station or someone calls the police, a neighbor, or someone calls the police and the police come to the scene, the police would counsel the alleged victim on the possibility of getting a restraining order. And if the alleged victim agrees to get a restraining order, then the police would then call the judge, who is on standby, narrate the facts to the judge, and the judge would decide, perhaps even talk to the victim, and the judge would decide whether to issue a temporary restraining order or not. Once a temporary restraining order is issued, remember, it's not permanent yet, so it won't be on the record, but it will be served upon the alleged assailant with a notice of date and time to appear before the judge so that there could be a trial on whether that temporary restraining order becomes a permanent or a final restraining order, which we call an FRO. This is very serious business because where an FRO is entered in someone's name, what that communicates is that in this society, a judge as listening to the evidence and deciding that that person is a danger to another person in a society. This can affect business opportunities. It can affect uh, job prospects. If there is a background check and it pops up, it can really be bad for a person. So you don't want to have a restraining order, a final restraining order on your name in the system. They're very difficult to deal with. They rarely go away, and they're there forever. So you take it very seriously. Now, in the case where you go to trial for a final restraining order, there is an opportunity to still resolve it. You can do what's called a civil restraint. This requires some finesse. It requires an attorney well, in most cases, you need an attorney that can handle the case professionally, be ready to try the case if necessary, and leverage that. Leverage the possibility of trying the case with success in order to potentially secure a civil restraint, which is simply a negotiation. Both parties will negotiate and say, okay, I want this, I want that, and it gets entered as an order from the judge. A civil restraint is just as important as any other order. It's just as important as the final restraining order, and it must be obeyed. In the case where the matter goes forward to trial, the alleged victim must prove two things. One, that there was an act of domestic violence, whether it was an assault, battery, a threat, harassment, a kidnapping, etc. Must prove any of those several incidents that are listed in the Domestic Violence Act in New Jersey. One. Two, you must also show the judge that there is a concern of it continuing into the future. Where you're able to meet both of those concerns, the judge will grant the final restraining order. If you are facing such a situation, it is very important to contact an attorney that can help you. Here at Omojola Law, we've handled these matters in the past with success, whether resulting in a civil restraining order, which does not go into your permanent record. No one can pull it up, or whether going to trial and beating the case, so that our client does not end up having a restraining order, in their name within the system. I am Ade Omojola from Omojola Law, and I am looking forward to solving your legal problem.